Should smoking marijuana preclude a person from government service? The answer to that question plagues many, especially younger people who aspire to work for the federal government. Several White House staffers were either asked to resign, got suspended, or are working remotely after their background checks revealed past marijuana use, exposing inconsistencies in the administration's employment suitability policies. Despite the fact that recreational and medical marijuana use is legal in 36 states and D.C., it's still illegal on the federal level, which is why the White House press secretary said last Friday in a tweet and again on Wednesday in a press briefing that they updated policies to ensure past marijuana use wouldn't disqualify staff. Even with the cannabis clemency applied, 5 people ended up losing their jobs. Additional security factors were in play in many of the cases involving staffers who are no longer employed, including for some hard drug use, a White House official told CNN. A source close to the matter also told CNN that the marijuana policy was not made clear to staffers before filling out their questionnaires. In a letter sent to the president on Thursday, 30 House Democrats called on President Biden to clarify his employment suitability policies, removing past cannabis use as a potential disqualifier, and apply these policies with consistency and fairness. President Biden has taken office in a time when the nation's attitude toward legalizing and decriminalizing marijuana is drastically changing. Last year, Gallup's survey showed the highest level of support for legalization among Americans to date at 68%. And 12% of U.S. adults said they smoke marijuana, according to a Gallup 2019 poll that's over 30.6 million people. With the tides turning, is this security clearance policy overkill? Joining me now is someone who knows the security clearance process intimately, former CIA intelligence officer Andrew Bakaj. He's currently a founding and managing partner at the Compass Rose Legal Group, a law firm that specializes in security clearance, federal employment, and national security law. Andrew, how many individuals are we talking about who work for the federal government in some capacity and need a clearance where this could be an issue?
Well, thank you for having me on. It impacts anybody who works within the Department of Defense, anybody within the intelligence community in particular, and anybody who requires a security clearance or any kind of access to classified information. So it impacts thousands of people, both government employees, federal contractors, members of the military.
I want to differentiate the White House, whether it's the Biden White House or any other White House, from those in national security. So let me first ask about the White House. Who sets policy on this issue for any particular White House?
Well, that would be up to the executive office of the president, presumably the president of the United States, to implement those policies with respect to the White House. But the president also implements those policies and procedures when it comes to access to classified information and what allows you to be suitable for access to classified information, to include drug policies, whether it's before federal employment or during federal employment.
My point is that the White House doesn't necessarily have the same policy as, say, the national security community.
That's true. And those policies can change if they wanted to. But presumably they would want to maintain consistency with what everybody else is required to do within the federal government, so that way they're not treating their own staff differently.
If I were seeking employment in the White House and I came to you as my counsel and I said, uh-oh, they're asking me on a form to acknowledge whether I've smoked pot currently or in the past, what would your counsel be?
Well, first of all, I would advise that they answer the form truthfully. Because if you lie on a security clearance form on the SF-86 and that comes out, then you can be permanently disqualified from obtaining a security clearance. Because nothing comes closer in time to your truthfulness, to your candor, to your reliability, to your judgment, than at the moment that you're applying for a clearance, when you're filling out that form. That said, going to the issue of marijuana use, I would have to ask them a number of questions. When was their last use? If it was more than a year ago, I would feel better. If it was a one-time use, I would feel better. If it's within the past year, I would say it's probably not going to work out. If it's heavy use over a period of time, there's going to be some mitigation that's going to have to be involved. So there may be a situation where, if somebody used marijuana, say 15, 20 years ago, and it was just a handful of times, we can mitigate those concerns because it's about mitigating the concern. But if it was heavy usage or more recent or within the past year, then that can impact the ability to get through the process. So my
if I wanted to work in national,
would be not to engage in that.
If I wanted to work in national security and I have to fill out the SF-86, I note that, put it up on the screen if we have it, that it says the following questions pertain to the illegal use of drugs or controlled substances or drugs controlled, yada, 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 in accordance with federal laws. And then it asks me, in the last 7 years, have I used drugs illegally? I could be in Washington, D.C., appropriate under D.C. law, but because this asks me under federal law, I would have to say I have done something that was illegal.
Well, you have violated federal law. And the issue that carries, what drives a train here is federal law. Did you violate federal law? And the answer would be yes. So anybody who's filling out the SF-86 has to read those questions carefully, because if you misstate something, then I have to make the argument if you hire me to appeal denial or revocation, to say, not only did he, yes, they may have used marijuana, but they didn't lie here, that this was an oversight. So you have to read the forms carefully and provide truthful answers.
It just seems fundamentally unfair. If I were a chemo patient taking, smoking pot for medicinal purposes somewhere in the country, right, with a prescription and legally, I would still have to say on this form, I've done something illegal. True or false? I'm limited on time.
Yeah, and so that goes to mitigation. So you may have a concern about smoking weed previously, but if it had something to do with for medicinal reasons, and there's evidence to support why, we can perhaps mitigate the issue and get you through the process. The one thing that I want to flag is I've had clients recently who have had their clearances suspended pending revocation for using CBD oil, hemp-derived CBD oil, which is lawful under federal law.
That is
ridiculous. Isn't just apply to. I'm sorry.
Sorry, I interrupted you simply to say that's ridiculous. Andrew, thank you. We'll have you back and continue this. It's a really important conversation.
Absolutely.